Okay, so I see a number of people joining. You're all very welcome here to the UCD Masterclass series exploring all aspects of neurodiversity. And this evening, I'm very pleased that we are joined, as per usual, of course, by Beth and Ken and myself, Timmy. But our speaker for this evening is Professor Michael Perlin, who is Professor of Law Emeritus at New York Law School, where he was Director of New York Law School's online mental disability law program and Director of NYLS's International Mental Disability Law Reform Project in its Justice Action Center. He's also the co-founder of Mental Disability Law and Policy Associates. He has written 34 books and over 300 articles, wow, on all aspects of mental disability law, focusing primarily on issues related to criminal law and procedure, therapeutic jurisprudence, and international human rights. He has litigated at every court level from police court to the Supreme Court and has done advocacy work on every continent. And I could say a lot more about Professor Perlin, but just to say, we were delighted to have you speak at a conference we organized with colleagues in May, and we thought your paper was so good, actually. We said, hey, we'll have you back for the Masterclass series, because it speaks to the justice system, but actually also to wider aspects of how we perceive and understand people's experience of the world. So thank you very much, Professor Perlin, for speaking this evening. And we look forward to lots of questions from our international and global audience. Thank you.
Okay, thank you so much for that very kind introduction, Timmy. I should just add one thing to that, to what was said. Before I became a professor, I was a real lawyer. I spent 3 years as the head public defender in Trenton, New Jersey. That's New Jersey state capital. And I spent 8 years as director of New Jersey's Division of Mental Health Advocacy, which was the first statewide advocacy program for persons with mental disabilities anywhere in the United States. So, I mean, that gave me, I think, so many insights into what I've taught and to what I've written about. But I want to share that with the audience because I think it's important you know that I have actually walked the walk besides talking the talk. So the title of my paper is Something's Happening Here, but you don't know what it is. And if any of you don't know where that's from, I'll explain it at the end. How jurors misconstrue autism in the criminal trial process. And I just went to press down there. So here we go. 50 years ago, virtually no one ever talked about autism. When I started practicing law, which was the early 1970s, it was virtually never mentioned. It was seen as a very, very rare disorder. Now it's well publicized, it's certainly well advocated, and it's fairly common. It comes from early altered brain development, neural reorganization, but look at these numbers of the prevalence. Is it that the percentage of people who have autism spectrum disorder have increased 500% since 2008, or is it just that it is being more recognized, that people are being tested? I think it's the latter. I think there may be an increase, but certainly nothing like that. What is very important, I've practiced law in New Jersey and New York, those are the states I know the best, is that its disparate impact on diagnosis, disparate impact on minority people. Minority children are less likely to receive such a diagnosis. They are disproportionately underrepresented in this group. And generally, the ones who are diagnosed with autism also have experienced significant intellectual impairments. And there's real under-recognition of symptoms of autism in some racial and ethnic groups. There are cultural differences that influence whether people are going to seek services, and no surprise, major socioeconomic disparities in access to those services. So this is something, if you put a little, yellow magic, a little Post-it on your computer, this is something worth having a Post-it for. It's defined in DSM-5, which is used in the US, and I understand it's not used in Ireland. But the two most important issues here, and I'll discuss them a little bit, are deficits in social communication and social interaction, restricted repetitive patterns of behavior, interests, or activity. And people in this cohort very often will have trouble with nonverbal communications, are seen as making poor eye contact. And that becomes so important when we get to the heart of what I'm going to be talking about how jurors respond to this population. People with autism very often have a difficult time understanding body language, facial expressions, and also maintaining social relationships, may often have very repetitive movements or repetitive language, and may display behavioral rigidity, one example being experiencing extreme distress to small changes, lunch being served at 12 instead of 12:30 or whatever. And these are the most common issues, but think about how some of these, not the lunch one, but everything else, might have an impact on a juror of 12 people who know nothing at all about autism, deciding in a criminal case. And this would apply also in some context to civil cases, although I'm not talking about that, how that would apply to them sitting in the jury box. It's difficult for a person with autism in the criminal justice system under any set of circumstances, but especially when their fate is to be decided by jurors who either have no familiarity or whose familiarity is based on a television stereotype. I saw it on TV, so that's the way it is. And who consider demeanor evidence in evaluating a witness's credibility. If you're taking notes, underline demeanor, because that is so important. It's probably the most important thing to talk about in this entire world. How it's processed is under the radar. And it's so interesting that half an hour before I got online, I got an email. I get a lot of emails asking me to sign up for continuing education. And the Federal Bar Association is doing a program coming up next month on autism in criminal defense. And I've never seen that before. I thought, wow, this is wonderful. And this is, of course, is for lawyers in the US. And I'll explain later why this may have special relevance to the federal bar. And if I don't remember, it's not on my slides. Please, somebody raise your hand at the end, and because I do want to tell it to you. So I hope that this conversation inspires some thinking about these issues. For those of you who are really interested in this, my colleague, Professor Heather Ellis Cucolo, who has written the article with me on which some of this webinar is based, she and I have a 10-week webinar course on autism and the law that we've created for Palo Alto University in California in the US through their continuing education branch called Concept, which stands for something. The C in the or continuing education, I don't remember what the other letters stand for. But if you are interested, this is something you might want to take. And here what I'm doing in this one, this PowerPoint tells you the scope of things that we are talking about in this course. Arrest, confession, incompetency, people with autism as victims, people with autism as witnesses, insanity, expert testimony, jury attitudes, that's today, trial process, ability to testify, and more. So again, if this is something in which you're really interested, that course, we gave the course last year, I believe, but it's available on their website if anyone is interested in registering for it. I have absolutely no idea how much it costs. Today, I'm going to be talking about just about jury issues, because this population, persons with autism, are seen as lacking empathy, as lacking remorse. And these are especially problematic in courtroom settings where jurors consider demeanor evidence in evaluating witnesses' credibility. How often have you heard someone say, oh, you could just look at him and know he's lying? Each of us heard this dozens and dozens of times. Just look at him. What does that mean? That we think we know by our visual observation of somebody's body language, their facial expressions or whatever, we can tell if they're telling the truth. Well, of course we can't, but we believe this. And this is so important in this context. And social impairment may lead defendants on the spectrum to make awkward expressions, to make inappropriate statements on the witness stand, or to kind of clam up, be unable to testify, to speak in public, even after they're on the stand. The case that I cite here, I don't cite many, although I love to cite cases. I don't cite many here. This is a New Jersey case. It was after I left practicing law in New Jersey, where the defendant had put in testimony to assist the jury to understand why he might act in a way that appears socially unacceptable to others. And the Burke case might be of interest to some of you. Again, if you can't track it down through your research tools where you are, let me know. Happy to send a copy. Remorse and compassion are so very, very important, and in terms of juror perceptions, and you can't let this go out of your mind for a minute. And the Supreme Court, the U.S. Supreme Court, knows about this. In 2002, in a case called Atkins versus Virginia, the court struck down the death penalty in cases of defendants with intellectual disabilities. Spoiler alert, many defendants with intellectual disabilities have been executed since that time. I've written about this elsewhere. But the reason they did so, to say that the demeanor of such defendants may create an unwarranted impression of lack of remorse for their crimes. Concurring in a major case called Riggins versus Nevada about a decade before, that said defendants who were on trial pleading insanity had a right to refuse antipsychotic medication, Justice Kennedy said, assessments of character and remorse may carry great weight and perhaps be determinative of whether the offender lives or dies. Riggins was a death penalty case. There is certainly no reason to expect that jurors would respond differently in more typical criminal trials or in other parts of the world. So we have to adopt a new approach. We have to provide dignity, and that's a word I'm going to be coming back to many times in the second half of my presentation, to the people at risk, and comply with the principles of therapeutic jurisprudence. This is something that some of you may know about, some of you it may be new to, but I believe it is the key to unlocking so many of the areas of the law that need to be unlocked. Voir dire, what does that mean? Voir dire is when judges explain to jurors during the process as to who is going to be selected for the jury. And the typical question is, do you know any of the defendant? Do you know the victim? Are you related to anybody? Things like that. But I believe that in doing the voir dire process involving cases of defendants with autism, the judges have to explain to jurors they cannot rely on their false, quote, ordinary common sense about what remorse looks like or what an empathetic person looks like. They have to tell them it's wrong. It's based either on media stereotypes or the heuristic of one person they may know. It cannot guide their behavior. Ordinary common sense is with quotes around it because it's not real common sense, a self-referential, it's non-reflective. I see it this way, everyone sees it this way. I see it that way, therefore that's the way it is. I love that movie, everybody loved that movie. I hated that book, everybody hated that book. You've all heard that many times. And well, that's relatively inconsequential, but here it is very consequential. So judges have to take great care in the selection of jurors in such cases, and questions have to be asked very specifically of jurors about their expectations, about their preconceptions, about what remorse and empathy look like. There has to be great care taken all the way along the line. Now, I believe here, and this is an argument I made a couple of years ago, it hasn't had much traction, but I keep saying it. I think there may be need for two experts. One expert who is a typical expert. I evaluated defendant X, and in my expert opinion, I found that he, she, blah, blah, blah. And a second expert to explain to jurors why their preconceptions about people with mental disabilities are all wrong. And I wrote about this in the Deceived Me Into Thinking I Had Something to Protect. As if you haven't figured out yet, it should be clear. I use Bob Dylan titles for many of my articles. Lyrics and titles, these are lyrics. Why multiple experts might be needed. And I think if I were consulting with a lawyer in these cases, that would be the first thing I would say. Move before the court to have a second expert appointed. Doesn't happen often, but I think it's so essential. At the end of the case, after all the testimony is in, the judge has to charge the jury, tell the jury, besides what the elements of the crime are, lots of other stuff. The judge has to be sure, or as sure as the judge can be, that the jury will incorporate sufficient information to make it less likely to infect the final case outcome. The impact of autism on a defendant's demeanor, how their preconceptions may not comport with reality, etc. especially because they may be negative influenced by stigmatizing belief. And of course, judges have limited understanding, limited familiarity with autism, and like jurors, will very, very often over-rely on this false ordinary common sense, as discussed in the Alleli and Cooper article that I cite here. Now, what's interesting is when jurors learn about this, they actually respond. 168 jury eligible participants, these are mock jurors, these are not real jurors, were given a vignette about someone who seemed to be suspicious. Half were told he had autism, half were not. Those who knew about it and understood what the etiology was, what the issues were less likely to find him guilty, were likely to be more lenient in the sentencing. They were more empathetic. Those who did not have this label, who didn't know, perceived him to be deceitful, remorseful, rude, and aggressive. Virtually all of the literature is in line with this. Now, again, this should not, I'm speaking, quickly because we don't have that much time. I wanted to leave as much time as I could for questions. You should not feel that's all there is to the trial stage. Autism is critical. The presence or absence of autism may be critical in cases involving competency, in cases involving responsibility, and in any kind of sentencing matter, whether, for instance, a sentence should be mitigated. That's worthy of a separate presentation. And I'm happy to do that. That was to Beth, Ken, and Timmy. And again, it's part of our course that I mentioned earlier on. Well, what's a possible solution? What about mental health courts? I know there are mental health courts in the UK. I don't know about your area of Ireland, so I'm on a tightrope without a net here. I believe that a mental health court that's created to understand the relationship of the neurological component of this population with the crime is needed to protect this vulnerable group of people, to make education and therapy available, to make recidivism a much less likely outcome. I'm a big fan of mental health courts. They can be controversial. The ones that work well do an absolutely brilliant job. At least one juvenile mental health court, one in Santa Clara, California, explicitly accepts individuals with autism. And it's interesting, it had to go out of its way, the people running the court, to say that, to make sure that such individuals would be eligible for such a course. Well, what do we do? What's a possible solution? And my answer here is that we should turn to the principles of therapeutic jurisprudence. It focuses on dignity, on compassion, which I don't mention here, which I should have, voice, validation, and voluntariness, to give lawyers and judicial officers the best opportunity to remediate all these issues that arise in this whole range of cases. What is it? TJ study. I was at a party this weekend. I don't know if there may have been a couple of lawyers there besides me. I don't know, but I'm in several bands, so I was sitting with a piano player and a guitar player. And the piano player asked me, like, what do I write about? And I told him. He said, I've never heard of this. I said, well, most people who aren't, in the game haven't. And he was fascinated. I'm just so happy to see how someone who was completely a stranger to all of this kind of took to and said, yeah, this does make sense. TJ, Therapeutic Jurisprudence, studies the role of the law as a therapeutic agent. And it notes that substantive rules, substantive legal procedures, and lawyer roles may have therapeutic or anti-therapeutic consequences. And the question is, should such rules, procedures, and roles be reshaped to enhance their therapeutic potential while not subordinating due process principles? That last half of the sentence here is the tattoo you should have. Reshape rules, statutes, court cases, procedures, court rules, roles, what the lawyer does, what the judge does, to enhance therapeutic potential and not subordinate due process. It cannot. Using mental health information cannot impinge justice concerns. It has to look at the law as it actually has an impact on people's lives. The two people I cite here, David Wexler and Bruce Winick, were the creators of therapeutic jurisprudence in the late 1980s. Bruce passed away some years ago, sadly. David is still at it. almost all that we have done in therapeutic jurisprudence flows from what David and Bruce originally wrote about. It supports an ethic of care. It tries to bring about healing and wellness. It values psychological health. I assure you, in all my years as a practicing lawyer, the words psychological health were never used by anybody. Total non-starter. Professor Amy Ronner has called, I love mnemonics, has characterized 3 V's as being part of therapeutic jurisprudence. Voice. Litigants must have a sense of voice, a chance to tell their story to a decision maker. Validation. If you feel the tribunal has really listened to you and taken your story seriously, you feel validated. And voluntariness. Voice and validation create a sense of voluntary participation. You experience the proceeding as less coercive. Professor Tom Tyler, who created the phrase procedural justice somewhere in the 1980s, I guess, did a paper, and I was so interesting. I remember this because I was on the podium giving another paper on the same panel, in which he looked at how people with mental disabilities feel about procedural justice, and people with mental disabilities' attitude towards procedural justice and procedural justice, voice and validation all over it, were identical to people without such disabilities. I think that's really interesting. So think about how TJ gives an individual client dignity, voice, validation, voluntariness, and also think about how compassion is such a core part of it. Well, it's especially important for an individual with autism whose behavior may be radically misconstrued by fact finders, by judges, by jurors. Consider first dignity. People possess an intrinsic worth. It needs to be recognized. It needs to be respected. They should not be subject to state treatment inconsistent with that. We also have to look at some of the ancillary issues. What are maladaptive? People are shamed, they're humiliated. What are the and certainly people with autism are shamed and humiliated. Think about the maladaptive responses: depression, hiding, avoidance, anger. Therapeutic jurisprudence highlights the worth and dignity of the individual human being. And I believe if we embrace this in the way we deal with people with ASD in all aspects of the criminal justice system, also the civil justice system, I believe everything will be enhanced. It's demanded not just by American constitutional norms, but it's required by international human rights law. When I was introduced, you were told I've done a lot of writing in international human rights. I have traveled around the world to try to get nations to implement the Convention on the Rights of Persons with Disabilities, and to ensure that people with mental disabilities have due process provided. Dignity is a big part of that. TJ also helps connect the lawyer and the client. And very often you have lawyers who are appointed by the judge 15 minutes before the case starts. They don't care about the case. They just have to do it because the judge told them to do it. But if we adopt TJ, we have a much better chance of creating some sort of connectedness. If we embrace TJ, that should diminish shame. It should diminish humiliation and create a greater sense of dignity. We infantilize people with autism. That robs them of their dignity. That dignity is a sine qua non of therapeutic jurisprudence. And you also have to keep in mind, one also has to keep in mind that the perception of receiving a fair hearing is therapeutic. It contributes to the sense of dignity that you're being taken seriously. And back to what Professor Tyler wrote about, he has written multiple times. It really matters. People think, oh, it only matters if you win or lose, but that's not so. People, when they're asked some lengthy probing questions, how they were treated very often means more than the ultimate outcome of a case. Psychological testing, review of all the developmental factors can yield critical information that provides mitigation, provides potential solutions that are consistent with the goals of therapeutic jurisprudence. Now, I got that from an article that I wrote about therapeutic jurisprudence and sexuality. And I want to actually just mention that now, because I remember I said earlier on that I got this email an hour ago from the Federal Bar Association's education group wanting me to sign up for a continuing ed course, and said, well, why is this important to the federal bar group? And here's the reason why. People with autism are disproportionately arrested for internet pornographic crimes, for downloading pictures that cannot be downloaded, for talking to people on the internet to make a date and finding out they're secret undercover officers. For a whole variety of reasons, people who are on the autism spectrum very often are at a much, their level of social sexual development is very often much below people who are not. And this is a way of them to meet people. This is how they learn about it. A good friend of mine, Valerie Mclean, who's a forensic neuropsychologist in Tampa, goes around the country literally talking about the impact of autism on defendants who are charged with federal crimes for which they can go to prison for literally a decade for. So I think it's very, very important to keep that in mind all the time. Again, humiliation, shaming, it leads to recidivism, it inhibits rehabilitation, it discourages treatment, and it eventually injures victims as well. And it contravenes the guiding principles of TJ. Again, as I said earlier, if we embrace the mental health court model, I think that's the best way to provide dignity and focus on procedural justice, and also use the principles of restorative justice. I have an article in Press Now and a book coming out by Cambridge Press on how therapeutic jurisprudence and restorative justice mesh. A draft of that is online on ssrn.com. You're welcome to download that. It also makes it much more likely, if there's a mental health court, that there will be continuity of care, which is very rarely offered to criminal defendants with mental disabilities of any sort, but it is much more likely to be offered if there is a mental health court vehicle to do it with. So I'm just about done now. People on this spectrum are vulnerable. Their dispositions of their cases are at the mercy of lawyers, experts, judges, juries, outdated court procedures, many of whom know nothing about autism or whose knowledge and beliefs all come from an episode of, of Law and Order or something. We have to be vigilant, confronting ignorance, rooting out bias, and also being aware of misguided pop culture beliefs. We've made advancements in this area in terms of people with psychosocial disabilities, mentally ill, severe cognitive disabilities, but we have to work harder to make similar advancements to provide accurate and reliable information about the ASD diagnosis and to educate all court participants, from the court clerk and the bailiff and the sergeant at arms up through the judge, on how to legally and therapeutically assist this population in the criminal trial process. If we embrace TJ, I think we are far more likely to make serious progress in these efforts. So where's my title from? It's from Bob Dylan's song, Ballad of a Thin Man. I'm not going to sing it for you, which will make you all very happy. But Bob Shelton, who's one of the great literary critics, musicological critics, says it's about an observer who does not see. Something is happening in these cases. And many of us, lawyers, criminal justice professionals, mental health professionals, and other concerned lay people, certainly truly don't know what is happening when members of this population have their futures put before a jury. We don't see what the ramifications of the process are. I hope that this presentation has helped clarify some of the issues. Thank you.
So, thank you very much, Professor Perlin, Michael, for your presentation. I mean, it raises a lot of issues. It answers many questions. I'm conscious, of course, that my own background is in nursing. So I have not had too many interactions with the legal system, but something that definitely chimed with me was the concept of the misconstruing of behavior. So, for example, in nursing, we always have to be very conscious of not jumping to conclusions. So it might be assumed that a person, for example, was under the influence of alcohol or intoxicated in some way, but actually the person might have low blood sugars, hypoglycemia, the person might have have some type of disorientation. They could have a subarachnoid hemorrhage. Who knows? So the importance of not misconstruing behavior without a thorough assessment.
That's so important to me. I'm so glad you said that, because we tend to look at things as we've looked at other things. So if you've seen 9 people walk into the ER presenting in a certain way, and all of them spike the breathalyzer, we're going to assume, it's human nature, that the 10th is going to also. But we cannot make that assumption. We have to do just what you said and rule out all of these other possibilities, hypoglycemia, whatever, that could be the reason for that behavior. I could not have said it better. Thank you.
And just to understand in terms of jury selection, I wonder, okay, I did some work in a quasi legal, quasi judicial part of professional conduct and so forth. And when you're working in the area of professional conduct, you have access to expert opinion, you have access to a legal advisor. And I'm just wondering, in jury selection, does the justice system do anything to look at either the knowledge base of juries, or do juries have recourse to any specialist advice, or is it incumbent upon the judge to direct the jury in these matters?
It is incumbent upon the judge. Jurors do not have sort of outside experts to go to. And very often the judge will use his alleged ordinary common sense. Well, I see it, it's as clear as day, and that takes care of it. And unless the lawyer, and by the way, in some jurisdictions, the lawyers are allowed to ask questions to the jurors on voir dire. In others, the lawyers must give their questions to the judge, and the judge chooses whether or not to ask them. So there's all sorts of complexities here that are suitable for a course in jury selection, which I'm not going into. But the point is that this is stuff that is very, very rarely explored. And of course, most lawyers don't have the background to even know what questions to ask. I will tell you, I'm going to confess error. When I was a criminal defense lawyer, I didn't know. And of course, this was the 1970s, when we all knew so much less, when there was virtually nothing in the legal literature. But now people should be under a greater responsibility. There should be more of a responsibility. And it's up to lawyers doing these kinds of cases to do that. I am hopeful that there'll be more articles. I write most of my pieces for law reviews and for what are called crossover journals, like psychology, public policy, and the law, things like that. But there are also journals published by the various Criminal Defense Lawyers Association, and every state has its own bar journals. There need to be more articles in journals like that, so that the lawyer who just picks up the New Jersey Bar Journal, the Florida Bar Journal, whatever, and leafs through it, will see it, and then maybe something will stick. I think that's very important.
And I know that Beth and Ken will be in with some questions from our viewers, but I'll take advantage of my exalted position here and ask another.
Sure.
I was party to a discussion recently. It was a little bit controversial, so I chose to just listen. But it was about autism, and one person was suggesting, in their view, that autism was a disability. And in their view, well, in Ireland, there are different legal terms. For example, the concept of diminished responsibility. And then also in our criminal law justice acts, we have a concept of not guilty by reason of insanity. But the concept of diminished responsibility, the person was advocating that diminished responsibility should apply if a crime had been, committed, but it was actually consequent to a particular developmental aspect. But the other person who was party to this discussion said, well, actually, autism is not a disability, and the idea of, it's a way of being. So the idea of diminished responsibility shouldn't apply. It got quite heated, actually, this discussion,
Sure,
and that's why I just listened. But I'm wondering, based on your experience, do you have any views on these concepts of diminished responsibility or other mental health acts that might apply in different jurisdictions?
There are two or three subsets of issues here to me. One is the whole notion of diminished responsibility. And that started out in a series of California cases in the US in the late 40s, early 50s. It was adopted by many states relatively quickly, but then about 10 years ago, more and more states started saying, no, there's no such thing as diminished responsibility. You're either not guilty by reason of insanity or you're sane, which is to me completely wrong-headed. I've probably written about the insanity defense more than anything else. I can go on until it's pitch dark here about that. I will not. And what's interesting thing is there are no coincidences in life, as you know. I just finished up an article on fetal alcohol syndrome and the criminal law. And this issue, whether or not diminished responsibility applies in those cases, is all over that. And I'm going to be doing a webinar next Wednesday in which I'm going to be talking about that in the context of people with FASD. On the question of whether autism is a disability, of course, one of the things I was thinking of, I used to be involved in representing people in the deaf community. And there is that the whole sort of the different worlds of people with deafness and their allies. My sense is that one can politically say it's not a disability, but I think for the purposes of the law, people, if it is considered a disability, people with autism will be punished less, will be thrown in jail for fewer decades, and will be maltreated less. So as far as I'm concerned, I'm going to continue treating it like that. I've gotten into long and very strenuous debates with people on the other side of this, not about autism, but about other psychosocial issues. And that's just kind of a political position, if you can take that.
Okay.
That makes sense?
Oh, it does. And actually, I may well follow up on your work on fetal alcohol syndrome. I've worked with people with that condition, and it would really interest me to hear about those legal aspects. So thank you.
You're welcome. The most recent paper I did, which has not been placed yet, is available online for free and easy downloading on ssrn.com. Put me in and you'll find it. You can download a copy.
Brilliant. Thank you.
Thank you.
So,
okay.
Ken and Bet, I hope you're ready for lots more questions.
And I see there's 6 Q&As and 4 chats, so presumably other people have some as well. Great.
But just a quick question, and just more for myself than anything else.
Sure,
just in terms of jury selection, is it a good idea to state at the very outset of the case that this defendant has autism, or does that sort of load up prejudice?
There will be some lawyers who will disagree with me. I know that, but I would state it if I'm addressing the jury, ladies, and again, I have not done a jury trial since the mid-1970s. Yes, I'm that old. I like to tell people I was 8 years old, but nobody laughs anymore. I would say, ladies and gentlemen of the jury and prospective jurors, this is a criminal case, but it's not like many other criminal cases. My client, who's accused of blah, 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 is a person with autism spectrum disorder. And one of the most important issues before us is whether or not you, the jurors, will be able to understand how that disorder may lead people to do things that may not compute to you, that may not make sense. And when you look at my client, he may not be responding to me, responding to the judge, responding to the person on the witness stand the way you expect a person to respond from having watched a lot of television. Please keep an open mind.
Okay,
if I was really doing it, I would do it better than that, but you get the idea.
Yeah, and I think that obviously I do have a million questions, but we'll probably go to the questions that are actually in the Q&A rather than listen to me talk. So the very first one was in from Hina. So are there any guidelines, recommendations, or examples of involving autistic or neurodivergent lawyers, judges, or jury members in the mental health court?
I missed the question part of that. I got the second half of what you said, but I missed the first half. So again, please.
Recommendations or guidelines for neurodivergent members of the court.
That's a great question. if you've seen one mental health court, you've seen one mental health court. There is no overall, I mean, there are guidelines as to mental health courts, there's guidelines as to drug courts, there's guidelines as to veterans courts, there's guidelines as to sex trafficking courts. But what I have found is that there is virtually nothing in common with most of them. Each judge runs his or her own court the same way. There are, I can send me an email and I can send you the names of people to correspond with who really are much more expert than I about these sort of, not 10 steps, it sounds like AA, but 10 criteria that any problem-solving court should meet. And you can use that as a jumping off point. But again, I know with veterans courts, there's a judge who comes into court with a camouflage robe on. There's another judge who refuses to hear a defendant's case unless he stands at attention and recites the Pledge of Allegiance to the judge's satisfaction. I mean, these are kind of like shake your head kinds of things. The best, I have 2 or 3 people that I have as the very, very best problem-solving court judges in the country. They adopt the therapeutic jurisprudence approach totally, and the proof is in the pudding. The recidivism rates are much lower. Their success stories are much better. By the way, people in Australia and New Zealand do this brilliantly. I've spent a lot of time there, pre-pandemic, obviously, observing those courts and watching the way the people who work in the court system who do this work with the defendants. It's absolutely brilliant. But that, again, that's a much longer answer.
No,
I mean, I have a much longer answer than I'm going to give you.
Just one more myself before we hand over to
Sure.
Beth. There's a question just in from Natalie, and this goes back just a little further. You know, if you're in court and you've obviously been in the criminal justice system and you've gone through various elements of it, and the question was, do they have autism ID cards in America?
No.
If you don't, could they be implemented?
I've not seen anything about that anywhere in the legal literature.
Well, just obviously, just we don't have them officially in line, but I know in the UK they do. I say you can get them from the police. You know, if you're having a difficulty, out on the street, you can just show the member of the force the card, and that will sort of head off things in the past.
Well, maybe. It also depends on who the policeman or policewoman is. I mean, each police department here is completely independent. There are police that I know who would be very thoughtful and accept that and really think about it. There's others who would just sneer or maybe kick the person around a little bit. So I'd have to be very, very careful. And I would need on something like that. I've written a little bit about how police treat people with mental illness. I have not written about how police treat people with autism. That's a completely new issue, Ken, and one I think deserves an awful lot of attention. I think having those cards might be a good idea, but I could also see it as backfiring. A shop owner not wanting someone with autism, because people with autism who hang around shops can be a pain to the shop proprietor, saying, unless you show me a card, you can't come in. And sort of what does that do? What sort of quasi law enforcement authority does that give to merchants? So I'm seeing as we're talking, I can think of about a dozen different issues, but I do like the idea.
Okay, thank you. Okay,
Beth.
Just as you were talking about police there, Michael, it kind of connects to one of the questions we've had here from a guest called Richard, who says that he expects a lot of these issues in jurors' misunderstanding would also apply to police officers who
even more so.
Yeah, and would
even
you
more
have
so
any? Yeah, go on.
I'm sorry for interrupting you, Beth. Pardon me. I mean, we know, and there's a lot of valid, reliable research on this, that police, even if they don't start out, when they become a policeman, woman, within 6 weeks in which they're acculturated to police behavior, become much more rigid, become much more, can't find the right word, negative towards people with disabilities. We know that. So I would think police would be far more problematic than jurors. But I think on the other hand, that if somebody who already works for the police department were to give a presentation to police about this, that might have value. If you were to do it or I were to do it, it would have no impact whatsoever. But somebody who has a blue uniform does it, yeah, that might have a value.
And you said you hadn't written much about the police and autism, but Richard also asked, would you have any tips that you would give to police officers in in kind of managing, interviewing us?
I mean, that's a great question. I've done an article about police behavior with people with mental disabilities in general. And if Richard sends me an email, I'll give him a copy of that. I think I might give him some ideas.
Great, thanks.
That one for Dylan fans is titled "How to Be Held Down by Big Police," which is from When I Paint My Masterpiece. I'm sorry, I can't resist, you know that.
Just you didn't, that hasn't been mentioned within the presentation, but when you were talking about earlier on about your the prevalence rates of autism, we know that autism particularly is 4-to-1 for boys versus girls. So is there any research done on the female autism interaction with the criminal justice system?
If there is, I don't know it. Virtually everything that I read, and before I write an article, Ken, I would like to say I've read everything that's written about it. That's impossible, you know. But virtually none of the literature that I read for my article talked about women. I will look that up. And if I can find anything.
Can I be co-author?
Sorry?
Can I be co-author?
Sure, absolutely.
Reference.
Let's talk about that. Absolutely. That's good. Okay. Other questions? Beth, did you have another question or not?
There was just a comment here from Kai, who says, thanks for an excellent presentation. And in relation to educating neurotypicals about neurodivergency, he or she, would point out that there is now much evidence for significant overlap between autistic and attention deficit disorders, underscoring the rationale behind the famous quote that if you've met an autist, then you've met one autist. Generalizations can be as much of a hindrance as a help in diagnostics. And I suppose that's kind of one of the challenges then that you're going to have in kind of educating jurors.
I think that's right. I mean, the whole notion of educating jurors is so murky in so many ways. One of my major areas of scholarship is the death penalty, and so much of that deals with preconceived notions by death penalty defendants, and to what extent is the case. There are some lawyers who believe the case is decided before the first bit of evidence is introduced, depending on who the defendant is, who the victim is, etc. What we have learned actually is that I had always thought that the most important thing is sort of and I apologize for saying it this way, the cutest victim, even if it's an African-American defendant, the cutest white victim is the most important issue in determining who gets a death penalty and who doesn't. What we have learned is that's wrong. The most important issue is the quality of counsel. And that in many states, judges specifically appointed terrible lawyers who are later disbarred for showing up drunk in court, et cetera, to represent death penalty cases because they wanted the death penalty to be invoked. So you've got all these other sort of sub issues. Each state is different. I did most of my litigation in Trenton, New Jersey, New York City, but I've done a little bit in Columbia, South Carolina, and Oklahoma City, Oklahoma. All I'll say is it was quite different. Okay. I don't know Ireland well enough to make the analogy, but you can figure it out.
Sure.
Yeah.
Sure, it's actually very, very interesting, I must say, because one of the notes I'd made here was that very issue of access to good representation and access to advocates. I know that here in Ireland we have a free legal aid system, and I know that any in Ireland we use the term solicitor. Any solicitor or indeed barrister I've ever met have been of the highest integrity and caliber, I must say. But I'm conscious as well that, in Ireland, there are many, celebrated firms, and, these are often the best and the brightest will be recruited. And perhaps in other contexts, people might not have access to that level of expertise or representation. And I mean, to conclude on that note, I know from watching American television, we all love.
I watch British television, so yeah.
Do you?
It's all I watch Britbox and Acorn. That's all I watch.
Yeah.
I watch a little Scandinavian, but almost all British, Scottish, Irish, noir mysteries. That's it for me.
Well, I grew up watching a show called Matlock. And
oh my God, I haven't thought of that in 30 years.
Pardon me?
I haven't thought of that show in 30 years, I said.
Oh, I loved it. I loved it. And
right.
But then of course more recently Suits, and you know, and shows like The Good Wife and so forth. And it just again got me thinking about resourcing and access to representation, and that is of course concerning that, you know, people might be allocated an advocate who.
Timmy, this is such an issue. I mean, there are many states in in the United States that don't have a statewide public defender system. Some are county by county, some are city by city, some have none. The judge just looks and say, Timmy, you're a lawyer, you're there for a bankruptcy case, Ken is there for an intellectual property case, Beth is there for a patent case. I'll say, oh, Mr. Frolley, I have a death penalty case for you. Mr. Kilbride, I have an insanity case for you. Ms. Kilkenny, I have an incompetency case for you. Yes, Your Honor. The three areas of law I just mentioned, I know nothing about. I would be incompetent to represent anybody in patent or intellectual property, whatever, but these lawyers do it. And one of the real issues, and I've written about till the cows come home, is how ineffective assistance of counsel cases are the most important cases in the American legal system, and how the Supreme Court is making it harder and harder for defendants to be successful. A completely unheard of case was decided 2 days before the abortion case in the spring, so you know nobody knows about it, called Shin versus Ramirez, has made it almost impossible for anybody to raise quality of counsel at the federal level and habeas corpus if it hadn't been raised first at the state level. So there's a lot there. We don't have that much time left, and I see there's lots of questions.
I was going to say, going back to a very simple one from Darlene's great question. From the other side, are people with autism ever accepted on a jury?
What a great question, Darlene. Write an article about it. I have no idea at all, and I don't believe, I'm writing this down. Autistic jury members. I don't think this is ever, I mean, they could be. I mean, certainly what happens is you get a postcard from the county clerk saying, come down to the courthouse Monday at 10 o'clock. So you're sitting in the jury pool. So a person with autism would be there. Then they'll say, okay, jurors numbers 1 to 50, go to courtroom number 7. So that person will go there. Then you're given a questionnaire to fill out. Autism would never come up in the questionnaire, but there are other things that might give, you know, things away. For instance, I was once there and they said, what magazines or journals do you read regularly? So I listed 18 different criminal law journals, and of course I was excused. But a lawyer, I think if a lawyer ever asked somebody about that, wow, would there be an explosion of, I think, you know, if a juror said, well, I want you to know that I have autism, that would be very different. This is a great topic. I don't know, Darlene, if you do any kind of scholarship, legal or otherwise, but man, this is a great, you'll excuse me, effing topic.
Thank you very much, Darlene. Just very quickly, just a personal experience. We have a 25-year-old son who has autism, who was called for jury duty here in Ireland, and went down, told me they had autism. He said, that's okay, you can go home.
Huh. I mean, that raises questions. I mean, you know, a whole notion of a jury of your peers, which is crap. It never is a jury of anybody's peers. But the question is, should they have sent him home? Raises a question. I don't know. I got to think about this, Ken. I can't do this one on the spot, on my feet.
Okay.
Improvising is hard.
Take one more, or will I keep going?
Keep going. Yeah.
You go ahead, Ken.
Got 5 minutes.
Sorry, I didn't read the next one. Regarding autistic defendants and empathy and remorse, is it an issue that these individuals don't show empathy and remorse in typical ways, or that they don't feel those emotions?
I mean, it's each case is an N of 1. But what I'm concerned about here, and sort of the focus of my talk, is jurors misconstruing what they perceive of the defendant sitting, and we don't have a box. The juror sits at counsel table with his or her lawyer, misconstruing. If somebody is giving certain kinds of testimony, of not reacting to it emotionally or reacting to it too emotionally, making those observations, and then from that extrapolating lots of stuff, including guilt or innocence. That's really the focus to be considered.
Maybe just one from myself more than anything else, and this is much of a political question that I was going to start off with because I like an argument. If you were to regard autism as a mental health condition and put it in mental health courts on this side of the Atlantic, your Twitter feed would go on fire.
I don't do Twitter.
Okay.
I do Facebook. I don't do Twitter.
Your Facebook would go on fire.
In
that autism would not be seen. There would certainly be a certain amount of the autistic population.
I understand that.
Who would not see it
again, there is this one court in Santa Clara, I think, California, in which specifically takes cases with autism. There was no opposition. Their Twitter feeds or whatever did not go on fire. It was accepted and embraced. So there you go.
Okay.
That's an N of one. I mean, we know about N's of one, but that is the only one that I know of.
Mhm.
So there's that.
And then there was a comment regarding jury selection. As a person with ADHD, I often only observe that only those with ADHD are truly able to understand me and my behaviors. And that we would see that a lot in ADHD Ireland, particularly around here. We run a support group for adults. And, the reason they come to the support group is because we would call it their tribe. In developing a jury of your peers for those that would be neurodivergent, how do you go about ensuring that it is a jury of their peers?
The short answer is you can't. There have been cases in which, say, I want to make up a country that won't offend anybody. Tanituva, that used to be part of the Russian Empire back in the early 20th century. I know that because I was a stamp collector. And somebody whose grandparents are from Tanituva is arrested. He or she would have no argument that they deserve a jury, that they have a right to a jury of 12 Tanituvans. That would not fly. There are cases that say you can't exclude all blacks from a jury. Case called Batson versus Kentucky is the lead case on that. But there have been many, many times in which all white juries have still sat, in which prosecutors have found other reasons to challenge every black defendant. So the jury of your peers, it's like In God We Trust. It's a shibboleth.
Oh, thank you. Just in terms, you talked about media, and we can take a couple examples. Recent more examples of The Good Doctor, which I don't particularly like, Atypical, which I do like. Do you think media has done anything over the years to improve the brand reputation of people that be neurodiverse and autistic, so when they do get to court, they get a better?
I think it's a limited yes. I mean, what I've looked at here mostly is people pleading the insanity defense. That was my focus here. Not people on the spectrum, but just people generally. And what I found was, back in the 1980s, the media would assume that the defense has pled every other case, that everybody's faking, etc. Now, when I get close, they'll say, Professor Perlin, we understand that the defense has not pled nearly as much as we think it was, and that most of the people who pleaded actually have a very legitimate mental illness. Is that true? Which means either they've read my stuff or they've read the stuff of other people who write like I do. I believe, in fact, I'm going to interrupt you, Ken, for a second, because I just wrote something down. I would like very much, if it's okay with you, and whoever is the chief person here has to tell me, I would like to put on my listserv, on the Therapeutic Jurisprudence listserv, to say that I'm going to say that I did this because I think you'd be interested, but also to list some of these issues in the hopes that somebody might be interested in writing about it. Would anyone have, nobody's names would be mentioned, obviously. Would anyone have any objections to that? Because I think scholarship about some of these issues would be so valuable. No complaints? No. Okay.
Well, thank you very much for your forthright answers to the questions. At this stage, I get to hand back to Timmy.
Okay.
Yes, and we're just approaching 6 p.m. So unless there's any other burning issues from Beth or Ken representing.
Have all the questions from the audience been answered?
Yes.
Mm-hmm.
Yeah, I think so. Yeah. There's some comments there. So yeah, but the questions are answered.
I hope everybody's enjoyed it. I had a great time.
Absolutely. And certainly, while I am not of a legal background, I think from a societal perspective, it would be really tremendous to see some more of your work here represented in Europe. And I'm sure if some of my legal colleagues were here, and maybe there are legal colleagues in the audience, but the therapeutic jurisprudence in particular, I feel has application here in Ireland. It would be really good to hear more of your work represented on that score.
I appreciate that, and I have a name for you. There's a young woman named Anna Kowalik, Kawalek. She's either at Leeds or at Sheffield. She was at one and went to the other. I just don't remember which it is. On all trustees, International Society of Jurisprudence. She has studied in depth mental health court in the England and in Wales, and I think she would be. And she's wonderful. She's a good speaker, and she's much younger than I am, and I think she'd be great. So, you know, I can send me an email, and I can send you her contact information.
Sure.
And she's just across the pond from you.
I will pop you an email, but you know, I'm not quite sure what age you are, but you don't look that old, I must say. You're perhaps on that note, I shouldn't make comments of that nature. I'll have to reflect on that. But
I appreciate it.
So a big thank you again to Professor Michael Perlin for an excellent talk this evening. A different topic to what we've had so far, but I think it certainly raised a lot of points and issues, and even answered a great number of those issues. Our next talk, we actually will have more representation from the United States. We have Professor Suzanne Brewier, and Professor Brewier has done a lot of work on labor, inclusive recruitment, employment, and actually that's what her talk is on, thankfully, inclusive recruitment and interviewing approaches. So I think that'll be interesting as well, because in a way it could be some continuation of the idea of perceptions and misconstruing how people present in themselves. So I think that's one to look forward to from Cornell University. So without further ado, we'll leave it there, and thank you again to Professor Perlin, Ken and Beth, and of course all of you for joining us this evening. Take care.
Thank you for having me. I appreciate it.
Thank you.
Thanks, everyone.